The right to privacy in the United States is a multifaceted and evolving concept that touches on both legal and cultural dimensions. While not explicitly mentioned in the Constitution, it has been recognized, developed, and protected through a combination of historical origins, landmark court decisions, legislative acts, and evolving societal norms. This comprehensive overview provides a detailed examination of the right to privacy in the U.S., from its historical roots to contemporary challenges in the digital age, and includes references to influential cases such as the Hogan privacy case. Historical origins of the right to privacy. The foundations of the right to privacy can be traced back to common law principles and Enlightenment philosophy. Legal scholars like William Blackstone articulated the importance of personal security and privacy against unlawful intrusions. The Fourth Amendment to the U.S. Constitution, ratified in 1791, established the right against unreasonable searches and seizures, providing an initial foundation for privacy protections. The Right to Privacy, by Warren and Brandeis, 1890. A pivotal moment in the development of privacy rights occurred with the publication of The Right to Privacy, an influential article written by Samuel D. Warren and Louis D. Brandeis and published in the Harvard Law Review in 1890. The article argued for the recognition of a new legal right, the right to be let alone, and explored the importance of protecting personal privacy from technological and media intrusions. It provided a theoretical framework for privacy jurisprudence. Griswold v. Connecticut, 1965. A significant milestone in the evolution of the right to privacy was the Supreme Court case Griswold v. Connecticut. This case challenged a Connecticut law that prohibited the use of contraceptives, even within the confines of marriage. The court, in a landmark decision, ruled that the Constitution implied a right to privacy in marital relations, extending constitutional protection to personal choices made within the privacy of the home. Roe v. Wade, 1973. In Roe v. Wade, the Supreme Court expanded the scope of the right to privacy. This case involved a Texas law that criminalized abortion except to save the life of the mother. The court ruled that a woman's decision to have an abortion was protected under the right to privacy, marking a significant moment in reproductive rights jurisprudence. Electronic Communications Privacy Act, 1986. As technology advanced, so did the need to address privacy concerns in the digital realm. The Electronic Communications Privacy Act, ECPA, was enacted in 1986 to safeguard electronic communications from unauthorized interception. ECPA regulates government access to emails, voicemails, and other electronic communications. USA Patriot Act, 2001, and FISA Amendments Act, 2008. The post-9/11 era witnessed the introduction of legislation that raised concerns about government surveillance and potential privacy erosion. The USA Patriot Act and the FISA Amendments Act expanded the government's surveillance powers. These laws have sparked ongoing debates about the balance between national security and individual privacy. Smith v. Maryland, 1979, and the Third-Party Doctrine. In Smith v. Maryland, the Supreme Court ruled that individuals have no reasonable expectation of privacy in information voluntarily conveyed to third parties, such as telephone companies. This decision established the Third-Party Doctrine, which has been a source of contention in the digital age as it pertains to data shared with internet service providers and social media platforms. Carpenter versus United States, 2018. In a more recent landmark case, Carpenter versus United States, the Supreme Court addressed the issue of warrantless access to historical cell phone location data. The court held that individuals have a reasonable expectation of privacy in their cell phone location records, signaling a shift in how privacy rights are considered in the context of emerging technologies. Privacy in the digital age. The proliferation of digital technologies has ushered in new challenges and dimensions of privacy. Issues such as data breaches, online surveillance, social media privacy, and the collection of personal data by tech companies have raised critical questions about the scope and protection of privacy in the digital age. State privacy laws and GDPR influence. Several U.S. states, including California, have enacted their own privacy laws, such as the California Consumer Privacy Act, CCPA. These state laws grant individuals greater control over their personal data and are influenced, in part, by the European Union's General Data Protection Regulation, GDPR. Hulk Hogan privacy case, Gawker Media, 2016. The Hulk Hogan privacy case, involving the publication of a sex tape by Gawker Media, highlighted the intersection of privacy and media ethics in the digital age. The case resulted in a substantial damages award to Hogan and raised questions about the limits of press freedom versus individual privacy rights in the era of online journalism. Ongoing debates and future directions. The right to privacy in the United States continues to evolve, shaped by legal developments, technological advancements, and societal shifts. Ongoing debates include questions about government surveillance, data privacy regulation, and the boundaries of personal privacy in a digital world. Balancing individual rights with collective interests remains a central challenge. In conclusion, the right to privacy in the United States is a dynamic and evolving concept deeply embedded in the nation's legal and cultural traditions. While its scope and contours have shifted over time, the fundamental principle of protecting individual autonomy and personal space remains a cornerstone of American jurisprudence. In an era of rapid technological change, the ongoing challenge is to adapt and expand these protections to address emerging privacy concerns in a digital age while preserving the essence of this cherished right. Warren and Brandeis' groundbreaking article, The Right to Privacy, continues to serve as a touchstone in contemporary discussions of privacy rights and their historical underpinnings.